Hi, today we're going to talk about trust registration. Is it necessary when you form a trust in the U.S. and what does it mean? Hi, I'm Richard Barid with Smith Barid LLC. I'm an estate planning attorney and one half of the Estate Planning Guide. Now guys, in the comments, if you can, you may notice my forehead is buffed to a high shine today, a little shinier than usual. So if that's blinding you, maybe look at it obliquely, don't look straight into it, but let us know in the comments if that's a problem. So you have a trust, a revocable living trust. We've talked about this before in very general terms. A revocable living trust is basically a container, a bucket if you'll think of it that way, to put your assets into so they're all in one place and being administered according to one set of rules, one plan, your plan. And when you pass away, it is not required that there be a probate of any assets that are in a trust, that are trust assets. In addition to that, if you become incapacitated, the person you decide, instead of the government intrusion of a judge deciding who's going to control your assets, you get to decide who is the trustee that takes over to control your assets, to take care of you and your kids according to the rules that you set up. So sometimes we get a question, do I have to register a trust? And I would say that may come from the idea that in many states, when you create a will, you can register it or place it for safekeeping with the probate court or the analogous court where you are in that county where you live, in the county of your residence. You can file a will for safekeeping, and that doesn't mean you're probating it. It just means that it'll be in a safe place, and whoever needs to find it when you pass away can find it. We don't typically do anything like that with trusts. Trusts are private documents. It's one of the things that our clients find attractive about it is whatever you're going to do and however much money you have, however many assets, whatever you're worth and whatever personal property you have, that's really no one's business, in our opinion anyway, but you. You can certainly share it with anyone you want to, but you shouldn't be forced to share it. And that's one of the things we like about a revocable living trust. It is a private document. It will govern who controls your assets, when, and how they'll ultimately be distributed. And just as important as that, what are they going to be made? How are they going to be managed by the person who comes along behind you as your trustee if you're incapacitated? It's an important question. So in the state of Georgia, as in many states, you actually have to file, when someone passes away, you have to file a will. If you know of know that the original will exists and it hasn't yet been filed with the court, it's a misdemeanor if you have that knowledge, especially if you have it in your possession, to not take it to the probate court and file it. That doesn't necessarily mean filing for probate, but it's usually the first step in that direction. We don't want, after someone's passed away, for their will to be lost or destroyed, because that would decrease the chances. So the trust can alleviate all that. It does not have to be registered. There are some rules and laws in the EU, and especially I believe the UK, that do require certain kind of registration. In most places in America, we're a little more private than that about our personal business, especially our personal financial. So what that means is when you form the trust and you move your assets into the trust, the only people who have knowledge of that are you and anyone you decide that you want to tell. You are in control. It's not a court, not any other government intrusion or intervention. It's you who gets to decide what is going to be in the trust and how the trust is going to distribute your assets and what's going to happen if you're incapacitated. All these important questions. Now, a will, a lot of people don't know this. They say, well, a will will be shorter. It might be easier to understand. Sure, I've got to file it with the probate court, but only the people who I want are going to find out about it. Well, that may not be true. Probate court, like other courts, at least in the United States here, are public record, except for very specific instances like guardianship or conservatorship. Probate records are typically, the probate files, the cases that get filed in that probate court, are public record. And that means that either while it's happening, probate, or after it has happened, people who are not a party to the case at all have a right to look at those documents, the public record documents, unless the judge seals them for some reason, which doesn't happen that often. And what a lot of people don't know is that not only do you have to file the will with the probate court, but in order to execute that will, the executor, the person named the person to execute the will, has got to make sure that the will you created and the petition to probate that will are served on every heir at law. And the heirs at law may be different than your beneficiary. I was dealing with a case just today where the heirs at law are 5 siblings, but the parent didn't have a great relationship with those kids and wants to leave the assets to charity. So sure, the charity can get notified, but the law requires that all 5 of those siblings who are getting nothing from dad's estate have to be served and either object to it, not object to it, or take some sort of action within a defined period of time. What we usually hope for is that the heirs at law, whether they're beneficiaries or not, will help us by signing basically a consent form to go ahead and get someone appointed as executor, get the bills paid, and let's start the distribution plan, or whatever it was that the that the person who passed away wanted us to do, the testator of the will wanted done. It takes quite a long period of time, and you can imagine that if you are an heir at law, which means you're usually a fairly close relative to the person who passed away, if you learn that you've got to do the work, such as that is, of reading the will, understanding, maybe getting advice from your own attorney, but at the end of the day, you either have to sign off or object or just let enough time pass. But this is even if you are not a beneficiary. So you can imagine getting served with that paperwork. Someone from our office calls you up, or some office who does what we do calls you up and says, hey, we sure would appreciate, and I know Dad would have appreciated, if you'll sign off on this consent form to name the executor Dad had named in his will as the official court-appointed executor. There are an awful lot of people, as you can imagine, who don't react well to being cut out of the will and then asked to do some paperwork on top of that. So we can avoid all that with a trust. A trust doesn't require that people who you are cutting out of the trust be notified. Unless your state has a specific law requiring that, in most states, the revocable living trust is entirely private. So even though you don't have to register it, you don't have to file it with the deed records, you don't have to file it with the probate court or the superior court, it is an excellent way to plan your estate with a little wall of privacy and protection around it so that the right people, the people you want to know about your plan, know about it and get the assets you want them to get, as opposed to having to register your trust with a court somewhere and have it be public record for anyone to discover. Hope that's helpful. We'll talk to you again next time. I hope you enjoyed that video. If you did, please click below to subscribe and hit the little bell so you'll get a notification every time we post some. Right now, we're posting about 3 videos a week with all kinds of useful estate planning information. So click right down here so you don't miss anything about estate planning, and click right here on your screen for the next relevant video.